professor of law at the University of New Mexico and specializes in constitutional law. Professor, thank you very much for joining us. Just take us through the argument that this should be tried in the Senate, given that Donald Trump is no longer president. That seems to be at the core of the arguments between the Republicans and Democrats.
Yeah, that is what we call in the United States the million-dollar question today. Our courts of law have to have jurisdiction over both the crime and the person, and we're focusing on the person. Does the United States Senate, sitting as a trial, have jurisdiction over a former president? I can share with you that the overwhelming view of the legal academy, meaning professors of law and scholars and researchers, is that based on our unique history in the United States Senate does have jurisdiction over the former president. And keep in mind this, President Donald Trump may be an ex-president, but he's also an ex-commander-in-chief, and he continues to receive a pension for the rest of his life from the United States taxpayer, much in the same way that members of the United States military who retire continue to obtain a pension. And it's that pension that gives the federal government, the military, jurisdiction over its members. Now, Trump is not amenable to the military's jurisdiction, but he's collecting the same type of pension that retired service members have. And so he could have forfeited that, he could have punted on that pension, but he chose not to do so. And as a former commander-in-chief, as a former president, the Senate would still have the authority to try him, find him guilty of the article of impeachment, and prevent him from holding federal office again. There is a very small number of attorneys, including, of course, his defense counsel, who disagree with that. But the weight of history and the writing, the basic text of the Constitution indicates otherwise.
So in theory, if someone made allegations about President Clinton, President Bush, about something they did in their time of office, and the House of Representatives impeached them, that they could be tried under the same precedent?
Well, in theory, as long as the offense was committed while they were president, one could take that argument to that length. It's never been done before, but that has been a matter of choice. I mean, if you look back to the Nixon impeachment, the Senate decided not to proceed with the trial, but not on constitutional grounds, but rather as a desire to create a healing, and also, after President Ford pardoned President Nixon in 1974, it was a desire to move on. But there was no constitutional infirmity to doing so.
I mean, you're not a political commentator, but I imagine you have a view on this. Would it not have been a better idea if President Biden had urged the Senate to follow the same precedent here and just let the country move on?
Well, these are different times than the post-Watergate, and it's a different event. And President Nixon left the White House. He didn't whip up a crowd of people to assault a constitutional process. I can see that argument that President Ford wanted a national healing to take place, and there's merit to that argument. On the other hand, what one could say that this is the first time in United States history where, if the president is guilty of the article of impeachment, that he stoked an insurrection against the very government and people that he was supposed to serve.
Okay, Joshua Kastenbo, thank you very much indeed. That's Joshua Kastenbo, Professor of Law at the University of New Mexico. Coming up in a
Thanks so much, Joshua.
Weatherman John